A grand jury, a majority of which was African American, asked in its official report for a federal investigation of voter fraud in Perry County because it was becoming very abusive and the black incumbent candidates at the time were rather terrified. That's the case that Senator Sessions brought as U.S. Attorney. And my question to you, Mr. Cole, is in your written and oral testimony, why did you omit the fact that the complaint came from African American citizens, from elected African American incumbent politicians, and the indictment came from a grand jury that was a majority African American? Why did you omit those facts?
Well, I don't think I intentionally omitted those facts, Senator Cruz. What I did was to express our concerns about several aspects of that case, namely that Senator Sessions, as the U.S. Attorney, investigated only counties, not just Perry County, but only counties where black votes had gone up, not where white votes had gone up, but only where black votes had gone up, number one. Number two, that he had conducted the investigation in an extremely intrusive way, addressing black voters at their homes, asking them how they voted, why they voted, etc. Number three, that he took the position, the legal position, that advising somebody on how to vote, on who to vote for, was a crime. Now, you, Senator Cruz, when you were running for president, advised people on how to vote.
Well, you also admitted the fact that the evidence in the case showed absentee ballots had been tampered with, and indeed the defendant in the case admitted that he had changed absentee ballots. He argued it was with the voters' consent, but he admitted he had changed absentee ballots.
Right, and if you're
and my point is simple, Mr. Cole. This committee can assess what occurred there, but any law student or any litigant who presented such a one-sided picture of the fact, conveniently omitting every single fact that is to the contrary, would not be treated as a credible witness and would not be treated, as you describe your testimony, as strictly nonpartisan. Let me turn briefly to a second issue you brought up, which was the Tyco case. You said the Tyco case undermined Sessions' fitness for the job as Attorney General. And likewise, there are a number of facts that you just omitted from your discussion. Number one, the basis of your complaints was submitted to the Alabama Ethics Commission. And on July 10th, 1996, the Ethics Commission unanimously dismissed the charges against Sessions for insufficient facts. Now, you briefly mentioned that in your written testimony, but you omitted it from your oral testimony. Fact number two, the Alabama State Bar, one of Tyco's lawyers, filed a complaint with the Alabama State Bar based on the trial court's order that you quoted, alleging over 20 ethical violations. The Alabama State Bar adjudicated that matter, and on February 16, 2000, the State Bar unanimously dismissed the complaint. Again, you omitted that fact from both your written and your oral testimony. That is nowhere to be found. But third, most strikingly, the language you rely on as the basis for your testimony. The Federal Court of Appeals, the 11th Circuit, concluded that that precise language concerning prosecutorial misconduct was, quote, particularly unreliable and misleading. It reversed a civil verdict based on it. And the 11th Circuit concluded there was, quote, no evidence in the record to support a finding that Tyco's federal constitutional rights were violated, and concluded that, quote, probable cause existed to prosecute Tyco. You omitted that fact that the Federal Court of Appeals profoundly repudiated that state court ruling you're relying on, and that, again, is not credible or impartial testimony. Now, I would ask the chairman for consent to introduce into the record the federal court opinion, the ethics complaint dismissal, the State Bar complaint dismissal, and related materials. And I'd also like to introduce a memo from Professors Ronald Rotunda and William Hodes concluding that, quote, the mere non-specific allegations of a party uncritically adopted by a state court judge and rejected by the state agencies with jurisdiction over ethics complaints cannot possibly have any bearing on Senator Sessions' ethical standing today.
Can I respond? Or no? Can I respond? Just briefly, and thank you. First of all, I did not omit that the Ethics Commission concluded that there was not an ethics violation, but that was a year before the case was dismissed for rampant prosecutorial misconduct. Second, I did not omit the fact that the 11th Circuit reversed a lower court decision for introducing that district court, that trial court opinion.
Say the federal court didn't question the reliability. The quote from the 11th Circuit is that the state court's opinion was, quote, particularly unreliable and misleading.
And that what it meant was, if you read the opinion, which I did, and Senator Cruz, you're now presenting misleading information, because if you read the opinion makes it very clear that the decision is based on a rule of hearsay and its relation to prejudice. In the abstract, it's a legal ruling. It is not a factual determination in any way, shape, or form.
Mr. Cole, my time has expired, but I would simply note the Federal Court of Appeals said, and I quote, "The statement of facts was intended to exculpate Tyco, and thus it was self-serving and unreliable." That is a verbatim quote from the Federal Court of Appeals, and it's contrary to what you've just told this committee.